United States District Court for the Western District of Washington is now in session. The Honorable Judge Kimberly K. Evanson presiding.
Good morning. Please be seated.
Now calling case C-256078, assigned to this court, the United States of America versus Hobbs. May I have appearances, please, starting with plaintiff's counsel.
Raymond Yang on behalf of the United States of America.
Kristen Johnson on behalf of the United States.
Good morning, counsel.
Thank you.
Good morning, Your Honor. Tara Heinz on behalf of Secretary Hobbs.
Christina Sepe on behalf of Secretary Hobbs. Renata O'Donnell on behalf of Intervenor Defendants Common Cause and Washington Conservation. And I'm joined by my colleague Brent Ferguson.
Tyler Bishop for Intervenor Defendants Common Power and the Alliance for Retired Americans, and I'm joined by my colleagues Ava Khanna and Walker McCusick.
All right. Good morning, everyone. We're here this morning on what are functionally cross motions. The government, the United States, has filed a motion to compel certain information from Secretary Hobbs. Secretary Hobbs and the intervenor defendants have filed motions to dismiss. The government's motion, and when I refer to the government, I mean the federal government, its motion was filed first. And so from that perspective, unless the parties have discussed and agreed otherwise, I believe it makes the most sense to begin with the United States and then hear from the defendants, Secretary Hobbs, and any intervenor defendants, and then again, let the United States and the defendants have the opportunity to respond to each other. Have the parties discussed any other arrangement or have an alternate proposal?
No, Your Honor.
All right. All right, then please, go ahead, counsel.
Question, Your Honor, how much time does each side have?
Well, I believe we have set this hearing for, did we set it? For 2 hours. But there's no obligation to use all of that time.
Yes, absolutely, Your Honor. Good morning. I may please the court, Raymond Yang on behalf of the United States. Last September, a representative of the United States Attorney General sent a letter to Secretary Hobbs requesting Washington State's statewide voter registration list, also called SVRL. This letter notified Secretary Hobbs that the demand was pursuant, as relevant here, to Title III of the Civil Rights Act of 1960. In particular, on page 2 of the letter, we stated that pursuant to the foregoing authorities, including the CRA, the Attorney General is requesting an electronic copy of Washington's complete and current voter registration list.
Counsel, can I interrupt you just for a moment and ask you to pull the microphone a little bit closer to you? I want to make sure that our court reporter can hear you. And also, just a general reminder to all the lawyers to please speak slowly so we can have a clear transcript. Thank you. Go ahead.
Thank you, Your Honor. The purpose of this request is to ascertain Washington's compliance with the list maintenance requirements of the National Voter Registration Act and the Help America Vote Act. This written demand was denied, and the United States accordingly moved to compel the production of Washington State's SVRL under Section 5 of Title III. As far as the United States is concerned, that is all that is required before this court compels Secretary Hobbs to disclose Washington's SVRL to the United States Attorney General. 1, there was a written demand notifying Secretary Hobbs that the demand was based on Title III and for the purpose of ensuring compliance with federal law. 2, Secretary Hobbs is an election officer defined under Section 306 of Title III. Number 3, the demand for inspection, reproduction, and copying was refused. And 4, the United States is seeking relief in the proper district court. Once those 4 conditions have been met, the proper course is for the district court to order the officer of election to permit the Attorney General or his representative to inspect, copy, or reproduce the demanded records.
Mr. Chang, let me stop you there. By my count, this is the 20th court to address this exact issue. Is there any meaningful basis on which to distinguish this case from the many other district courts and the Sixth Circuit Court of Appeals across the country that have dismissed the government's complaints or denied their motion to compel?
No, Your Honor, all the relevant facts are similar to all the other cases. And as I would note, unfortunately, district courts across the country have misconstrued the text, context, structure, history, and original understanding of Title III to the point that the Title III as exists in 2026 is foreign from the Title III that existed as it was originally enacted.
Well, no,
Based-
since you raised the history of Title III, and I'm glad you did, because I have a question about that. Several courts have discussed the history of Title III, which, as I'm sure you are aware, was enacted as a component of the Civil Rights Act of 1960 and meant to provide the Attorney General with the tools necessary to investigate allegations of voting discrimination against African American voters. Specifically, the provision requires local elections officials to retain records that they receive from voters for 22 months after an election to combat the practices of certain states at that time of destroying or discarding voter registration materials from Black citizens. And for that reason, the statute criminalizes altering or destroying any such record. Now, the Sixth Circuit, in the Benson case, very recently, last month, I think, observed that in these cases, the United States now seeks to invoke Title III for the inverse of its original purpose. That's a quote from the court. Not to ensure the free exercise of the franchise, but to ensure that some people have not voted. So how should the court treat the government's use of Title III in this case in light of what these courts, at least, have documented the history of Title III to be?
Well, Your Honor, we would distinguish the purpose, the reason why it was enacted, from what Title III actually means. So, of course, in a context, the federal government decided to enact an inspection regime for the purpose of ensuring that voters were not denied based on the race or color. But the meaning of Title III is to create an inspection regime on registration practices by state and local officials, and is that meaning that controls whatever the reason why it was enacted. Now, it's important to note that even when it was enacted as part of the Civil Rights Act of 1960, Title III does not really refer to race at all. For example, the criminal punishment for destroying, mutilating, or altering any record that's not cabin to destruction, mutilation, or alteration to obscure a denial of the right to vote on a basis of race. We have Title VI, on the other hand, that does mention race. So the absence of any race or color limitation to Title III suggests that it was intended to apply broadly. And we even see that in the legislative history. A lot of courts have sustained Title III on a constitutionality, Title III's constitutionality on the 14th and 15th Amendment. If we look at the legislative history, they thought the authority of Title III, when they were talking about the authority, they cited United States versus Classic. That case is solely on the Elections Clause. And to any argument that Title III can only be limited to race, well, the NVRA also has a public inspection regime, which is different than Title III. Is that now perhaps in constitutional doubt? So we think that Title III has no race or color limitation for purposes of retention, preservation, and demand from the Attorney General. Now, of course, as you mentioned, the United States has lost in every case that was filed in 2025, that's been decided in 2026. That is not the case if you look back to the 1960s. The first courts that were allowed to interpret Title III interpreted it the way that we think it should be interpreted.
And
Now,
were those cases that you're referring to in the 1960s, were they seeking materials more in line with the text of the statute, as in materials provided or materials that come into the possession of the election official?
Your Honor, we think that the materials provided in those cases is actually inconsistent with what the Benson Court called an external source limitation, which of course is the predominant reason why district courts across the country have denied the Attorney General's demand. So the external source limitation argument goes that comes into possession can only mean things that are received, or in other words, submitted by voter applicants. We think that's wrong for various reasons: text, context, structure, and the original understanding, especially by the courts. So text, as several courts noted, can be a synonym for acquire, but acquire has a very broad meaning. Acquire, as the OLC opinion discusses in, I believe, pages 7 through 10, acquire is to obtain by any uncertain mean. If you look at Black's Law Dictionary, when it defines acquire, you can acquire something by one's own exertion, one's own effort. And right below that, there is the concept of original acquisition, which is basically at the time you acquire it, you've created it. So you can create something and then come into possession of that. Justice Marshall understood that in a tax analyst case where he comes into possession semantically consistent with records that are created by the possessor. So at least Justice Marshall did not think that comes into possession semantically excludes internal records. We have another example, which was found later after briefing, and allowing to discuss it. In 1992, Congress sought to preserve and disclose records that related to the assassination of John F. Kennedy, and it defined assassination record as, quote, a record that is related to the assassination of President John F. Kennedy that was created or made available for use by, comma, obtained by, comma, or otherwise came into the possession of certain government officials. As that definition is written and phrased, something that is created is an equally valid way of coming into the possession as something that is obtained by a government agency. And that
I'm sorry, counsel, what are you quoting? What case is that?
This is a statute, JFK Records Act. It is in 42 USC section 2107.
And help me understand, if comes into possession also means created, why does the statute say created or comes into possession? Why should they mean the same thing?
Well, Your Honor, it's just simply explaining that created is a way of coming into the possession of something, like being a government agency obtaining it, right? So under Benson's reading, something that is created by a government agency is distinct from something that is obtained by a government agency. But Congress, in the way they phrase this in this statute, think that both methods are equally valid ways of coming into the possession of something.
But
So
doesn't that mean that that statute encompasses records that are either created or come into the possession of, whereas here, the statute says only comes into the possession of? Doesn't that actually undermine the United States' argument?
No, Your Honor, our point is that semantically speaking, coming into the possession of something can include something that is created and as well as something that is received, consistent with Justice Marshall's use of the phrase in tax analyst. Even in the legislative history, in the House Conference Report on the draft bill that eventually became Title III, the draft bill, of course, used comes into possession, but the House clearly thought that the ultimate import of the phrase simply means in the possession of an election officer. I believe that's on page 6 of the House report for this bill. So we think that even Congress thought at the time that there was no distinction, that comes into possession is a synonym phrase for in the possession of something. So that's, I think the United States position is that comes into possession is clearly meant to encompass both internal and external records. But at the very least, if you disagree with that, we think there is enough ambiguity to look at the other indicia why comes into possession can include internal records. And we can look at the context. So Title III, Section 301 covers records relating to acts requisite to voting. And the examples they used are application, registration, and payment of poll tax. Now, in our briefing, we explain why an external source limitation would basically nullify Title III coverage, right? There would be nothing that would be covered because anything that is a record was already given, was created by a government official and then given by a voter applicant, right? Any record related to a payment of poll tax has to be created by a government official because the applicant is only furnishing money. I will also now direct the attention to the word registration.
Well, I want to make sure I understand what you just said. So you said that the external source limitation discussed by many courts, but recently in the Sixth Circuit decision in Benson, it doesn't make sense because the government creates all the records in the first instance
For the payment of poll tax, yes, Your Honor.
for the payment of a poll tax, but I think it was the Benson court that discussed the history of the payment of the poll tax, which wasn't it that was the functional voter registration system at the time, whereas a voter would come and pay their poll tax, receive a receipt, and that was their voter registration. So then providing that to the officer so that they could vote, that receipt was what was protected by Title III.
But Your Honor, the reason why Title III was enacted is to investigate and scrutinize registration practices. So the coverage should have already been there even before any person decides to cast their vote, right? So any record we think relating to paying poll tax includes a list or a book of those who paid poll taxes. But I want to turn this court's attention to registration. The Benson District Court, in first concluding that Title III only includes information submitted by voters, clearly thought that application, registration, or act requisite to voting is only things done by voter applicants. We think that's actually wrong. We think that as originally understood, an act of registration is an act that can only be performed by a government official. And I want to cite some codes contemporaneous at the time from the South. So the following citations are all from the 1940 Alabama Code, Title 17, Section 21. Registrars. Registration shall be conducted in each county by a board of 3 reputable and suitable persons. That's the Board of Registers. Title 17, Section 21, discussing board of registers to hold fixed meeting and give notice thereof. Boards of registrar will attend to register applicants for registration. Section 27, the board, and I'm going to skip some parts, shall remain in session of each said meeting for 10 days for the purpose of registering persons entitled to register. Section 28, list of names registered by precincts to be published. The judge of probate shall, and I'm going to skip some other parts, make correct alphabetical lists of all electors registered. And Section 29, board registers shall enter in the book the names in alphabetical order. And I'm going to talk about the Louisiana Code. Same thing here.
But hold on, counsel, let me stop you. Why are we talking about state election codes?
Because Title III was meant to cover election practices by state and local officials. And of course, when they talk about registration, they will have to cover what election officers were doing. That's why election officers is also defined under Section 306. The point is, an act of registration is an act performed by a government official. And if that's true, it makes no sense then to impose an internal source limitation on Title III, because any record related to an act performed by a government official has to be internally created. Again, the Louisiana Code, Section 2629, the registrar of voters shall make a new and complete registration of the qualified voters of their respective parishes. Section 2621, the registrar of voters shall cancel and erase from the books the names of all such persons so reported and may have been registered. Thank you, Your Honor. Or sorry, thank you. And said registrar shall also keep a book or books for reference of all reports so made to him under the provision of this section. And again, even in the criminal provisions of the Louisiana Code, it talks about how persons attempted, right, or shall cause his name to be placed, or shall attempt to have his name placed upon any book of registration. He's not placing the name. The statute clearly envisions that somebody else is placing the name, which is an act of registration. Now, colloquially, we agree that in common day language, in 2026, we speak of voters as registering. That is not true when Title III was enacted. Even the modern Washington statutes. So the Washington Code, Title 29A-08110D, speaks about, for example, the date that an election official receives the information to register the person to vote. If we look at the 1951 Washington Code, it's even clearer. Title 29 of the Washington Code has been repealed, but existed back then. So Title 29, 07020, city clerk as registered in city precincts. It talks about, quote, the voters' registration is done by a registrar, right? I think intuitively, we can categorize it as this. Voter applicants make applications, registrars make registrations. And if that's true, it then makes no sense to impose an external source limitation on any record or paper relating to an act of registration. By the way, according to Black's Law Dictionary, the 4th edition, which is the most recent edition at the time when Title III was enacted, the most common meaning of record is something done under law by a public official. So that clearly indicates that they were concerned about registration practices and wanted to cover any writing that memorializes what they did in response to people who wanted to vote. I think the context is even clearer. Of course, In re Galliant and the House Conference Report discuss In re Wallace, which was about voter and registration records and how the commission tried to get those records but were denied, and Congress, as a result, sought to create a new provision of law, Title III, that would, in effect, basically prevent In re Wallace from happening again, in particular to the Attorney General and the Department of Justice. I think it's important to note that if Title III did anything, it was to cover the records that were at issue in re Wallace. Now, what records at issue were not specified in the Westlaw Reporters, but they are specified in the Race Relations Law Reporter. And in Volume 4 of the Race Relations Law Reporter, on page 99, it reproduced Exhibit A, which describes, I'm going to read this, quote, Exhibit A consists of the subpoena and return to Circuit Judge George C. Wallace. Attached to the subpoena and incorporated by reference is the following list of documents to be produced. Number 1, official register of qualified voters. Number 2, orders for disbursement of state funds to members of Board of Registrars, January 1st, 1955 through November 18th, 1958. Number 3, all names registered in Bullock County each year for years 1956, 1957, and 1958 as furnished by the Board of Registrars. Number 4, all names registered in Bullock County each year for years 1956, 1955, and 1958 as compiled by Judge of Probate. 5, records of Board of Registrars containing application, questionnaire, and oath for each applicant for years 1956, 1957, and 1958, which of course is not inconsistent with our argument. Our argument includes internal and external records, both.
So let me just pause you there, counsel. Even if the court were to accept this argument, what you're listing off is all names registered, and Secretary Hobbs offered a list of all names. It's a publicly available list. Why does this support the argument that the government is entitled to this sensitive information of millions of voters?
Well, Your Honor, that's because Title III contemplates disclosure of sensitive information. For example, it obviously contemplates disclosure application forms, and application forms have private information. If anything, an SVRL is simply a compilation of the information that already exists in application forms, right? The last 4 Social Security, the driver license number, that information already exists in application forms, which I don't think even an external source limitation would exclude. So at the very minimum, Title III already covers things that contain the information that state and local election officials have subsequently compiled.
So the state and local election officials are required to retain that information for 22 months. But what the government is asking for is a living document, a computerized list that would far exceed the temporal requirements for retaining those materials. How does that fact support your interpretation of Title III?
So, Your Honor, we think I'll address the second point. Title III is a continuing obligation, so they are already required to retain it on a continual basis. Now, the 22 months is a temporal maximum as it relates to an election. It does not mean, and the courts, I believe, might have been Owens, but one of the 60s cases actually, I think it was Lind, when they put a footnote about permanent registration. It does not mean that records and papers only have to be retained for 22 months. All records and papers relating to acts requisite in voting in the most recent election had to be retained for 22 months, as well as a continuing duty to retain and preserve all records and papers in any upcoming election. So, as the Lynn Court explained, if you have a permanent registration, what would happen is Title III will reach as far back as when the person applied. So, hypothetically speaking, let's say Title III now covers the 2024 general election. The application made by a voter in that election was made, let's say, in 1979. Our position, as adopted by the Lynn Court, is that Title III will reach all the way back to a 1979 application because it is a record and paper related to the most election.
So, I'm sorry, is it the government's position that Secretary Hobbs is required to retain application forms going back 100 years?
So long as it relates to the most recent federal general election.
So then what does the 22 months limitation mean?
The 22 months limitation in the legislative history was a compromise to allow people to throw away ballots. So for example, if you voted in 2024, that ballot doesn't relate to any 2026 election, so 2 months before the 2026 election, that ballot can be thrown out. That's why the time period was 22 months as opposed to 24 months. Back then, they thought that ballots even were covered, as of course referenced in McIntyre versus Morgan that we cite in our brief. But again, all this stuff that was fought over in Ray Wallace is completely inconsistent with an external source limitation. We even see that in Section 306. So Section 306 defines an officer of election as any person, as basically any person under color of law, whether it's federal, state, commonwealth, or local law, statute, ordinance, regulation, authority, custom, or usage, who performs or is authorized to perform any function, duty, or task in connection with any application, registration, payment of poll tax, or other act requisite to voting. We think that is an extremely broad coverage for individuals under Title III if all Title III was concerned about were election officials who only received documents from voter applicants. We think the reason Section 306 covers individuals who performs any function, duty, or task is that if they create a record in the course of performing that function, duty, or task in connection with any act requisite to voting, they have made a record that is now subject to Section 301 retention and preservation requirements. And I think courts back then understood. We have, of course, the Lynn case talking about records prepared or compiled. Your Honor, this is not in the record, but I can provide a photostatic copy after oral argument. So in Kennedy versus Owens, the Fifth Circuit discussed about the extent of Title III, and in doing so, it reversed the district court that denied records and papers as it relate to Owens as registrar. The court below granted the application as it pertained to records and papers in the possession of Owens as circuit clerk, but denied it to Owens as registrar. If you look at, and most importantly, the Fifth Circuit directed the district court to grant the application as it related to Owens as registrar. If you look at the district court opinion below, what it denied include things like registration books and poll lists, documents, records, papers that are inconsistent with external source limitation. So again, we see the text, the context, the structure, as well as the original understanding, all in tension with external source limitation. I think that is because Title III, as it was originally elected, clearly contemplated covering things created by election officials in the course of their duties. And it wanted to do such inspection on a relatively rapid basis. If you look at all the opinions in the 60s, to the extent that they discussed how long it took, they were at pains to say that they were exasperated by how long it took from the demand, the refusal, all the way to inspection. I think that's because, as the Lynn Court recognized, the federal rules, to the extent they apply, are not supposed to create any record demand into a trial-like proceeding. That is clear in Lynn itself.
Let me pause you there for a moment. So you have argued here that the federal rules of civil procedure do not apply. No district court to consider this argument in similar cases has agreed, and some of those courts have explained that even if the rules did not apply, the outcome would be the same. Do you agree that whatever procedure applies, the court must decide whether the list, the voter list, is subject to Title III?
We agree with that, Your Honor.
All right.
And to the extent they do apply, I think the Fifth Circuit in Lynn correctly recognized they only apply to the extent that it affords the election officer a notice and opportunity to be heard. I think that's clearly the case here.
Though this case was filed by virtue of a complaint in a civil action.
Your Honor, it's titled as a complaint, but content matters over caption. We cited a bevy of cases. We even cited one Supreme Court case where it construed something titled as a complaint as an application. The federal rules of procedure, by its own words, only applies to civil actions. Lynn clearly says this is not a traditional civil action. And indeed, if this court were to construe Section 305 to include the application of federal rules of civil procedure, we think that creates its own surplusage, right? Because what would appropriate process mean if it instead just means every other process afforded by the federal rules of civil procedure? We can compare that, for example, to Section 302, the criminal statute. There's no detailing process. That's because we think the federal rules of criminal procedure apply, because they didn't specify it. We even see that in Section 306, where they talk about upon application, and the court construed that as basically a simple process. Oh, by the way, I want to mention that Title VI also supports our argument against an external source limitation. And that's because...
Counsel, just a second. So on the rules issue, though, I mean, we're all here. The motions have been briefed. We're in court. There's no issue with respect to notice or opportunity to be heard. Do you agree at this point that it doesn't actually matter whether we say the civil rules apply or not?
Your Honor, it wouldn't matter moving forward, but yes, Your Honor, it wouldn't matter here at this time because everything that has already been done required for this court to make a ruling. But as I was saying, Title VI, in particular of the CRA, creates a cause of action for pattern and practices that are racially discriminatory. Note again, Title VI includes race and color. Title III does not. But the reason why they have such a cause of action is, again, to scrutinize government acts. Right? If the whole point of Title III is to help Title VI work together and to allow the federal government to have an easier time prosecuting pattern and practices discrimination, it would be incongruous to then, of course, reduce Title III to only include external sources.
But the United States here has not alleged that the purpose of this investigation has anything to do with voter discrimination on the basis of race, correct?
That is correct, because we believe that Title III is not limited to just race and color. We believe, as the courts contemporaneously have stated, it can be for a violation of any federal law. It is a general inspection regime. Now, of course, it could help racial investigations, but our point is it's not limited to racial investigations.
I understand. I just want the record to be clear that that is not the government's theory here.
Yes, Your Honor.
All right. And in addition to the Title III issues, many other courts, since we're talking about the purpose, have concluded that recitation of the government's intent to evaluate compliance with list maintenance requirements in HAVA and the National Voter Registration Act is not a sufficient statement of a basis or purpose under Title III. Here, I understand your argument to be that just merely stating the list maintenance requirements in those statutes is enough. Is that a correct statement of your position?
Yes, Your Honor. We believe that a general assertion of a basis and purpose is enough to satisfy Title III. We believe that even a legal basis is enough. If you look at...
But the government does not have to put forth a factual basis?
No, Your Honor, because as the Lynn Court said, any factual determination is not even up for review. So even if we allege the factual basis, it is no answer for the registrar to then say, I haven't done anything wrong, or your factual basis was wrong. If a response that the factual basis was wrong is not a defense against a Title III demand, it makes no sense, of course, then to require a factual basis. We believe that a legal basis is what is required instead because it comports with the concept of notice, right? So in the letter in Re Gallion, which I can provide as well later, in Re Gallion, the letter addressed in that case actually starts with the following phrase, pursuant to Title III of the Civil Rights Act of 1960. And it even attaches a copy of the statute. We believe that's because the federal government can make, generally, in the course of communicating with other individuals, can even communicate with state officials. But by requiring the federal government to tell in the letter that this is pursuant to Title III puts the election officer on notice the maximum extent of what is covered and puts them on notice that a refusal would result in a proceeding in district court to compel them to disclose that record.
All right, counsel, I'm going to ask you to wrap up because you've been at about 40 minutes and I want to make sure you have adequate time to respond.
Okay. Again, Your Honor, all we ask is that Title III be construed to, as it was originally understood by courts, the legislatures, and the people, consistent with the words as they meant back then, and to be consistent with the words and the understanding of Title III as it was back then. An external source limitation is utterly inconsistent, and therefore, the government's motion, the federal government's motion to compel should be granted, and the defendant's motions to dismiss should be denied.
Thank you.
Good morning, Your Honor. Tara Heinz on behalf of Secretary Hobbs. I'll be splitting time with interveners.
All right, that was my first question. Thank you. All right,
Yes.
I'm going to trust that you'll keep an eye on the time then.
I will, Your Honor.
All right, thank you.
As of this morning, 20 district courts and the Sixth Circuit Court of Appeals have now unanimously rejected DOJ's effort to obtain state voter registration lists. Many of these courts have denounced DOJ's efforts for what it is, an illegitimate attempt to usurp state constitutional authority over which voters are allowed to register and vote in elections. This court should add its voice to this remarkable and important judicial consensus and repudiate DOJ's unprecedented and dangerous demand for the confidential information of hundreds of millions of voters. None of the statutes that DOJ cites grants it such breathtaking authority. I plan to address the Civil Rights Act, the National Voting Rights Act, and the Help America Vote Act, as well as any questions this court might have about application of the Federal Rules of Civil Procedure to this case. Mr. Bishop intends to address the Privacy Act, and Ms. O'Donnell will address the issue of pretext. Starting with the Civil Rights Act, the state voter registration list is simply not a record or paper that must be preserved or produced to DOJ under the CRA. This is a matter of simple statutory construction. And it's clear from the text itself, the CRA, particularly its use of the term come into possession, as well as the finite retention period, the 22-month retention period, as well as the term retain and preserve. All of these point to the SVRL not being a record or a document within that scope.
What's your response to the government's argument that Secretary Hobbs is required to retain all election-related materials for 100 years or more?
Your Honor, that does violence to the text of the CRA. It reads out the finite retention period altogether. So DOJ's, in order to contort the language of the CRA into the purpose in which it's tried to use it, would like to read out the term comes into possession. It would like to read out the 22-month limitation. It would like to read out the language retain and preserve altogether. So this interpretation is entirely inconsistent with the text of the CRA itself. Starting with come into possession. That is a unique term. It is not as broad as the term possess or maintain, like the statutes that DOJ points to. It does not mean create. As the Sixth Circuit aptly explained in its opinion, when you pull a cake out of the oven, you would never say you have come into possession of the cake. It is a unique term, and it does not apply to documents like a dynamic voter registration list that is constantly updated by election officials as required by federal law. Now, ignoring this meaning and applying a very convoluted and not ordinary language, DOJ argues that comes into possession can apply to documents that are created by an agency. But it really makes no sense that Congress would have used this very specific term, comes into possession, rather than the much more common term possess, which is the type of word that under every other broader statute that DOJ points to. And every single one of its examples actually undermined its argument. In its moving papers, DOJ points to a number of different statutes that use the term come into possession, and every single one of those statutes are talking about documents that are acquired by an agency or a third party. So for example, DOJ pointed to 44 U.S.C. 3572. But at the very beginning of that statute, it says that its purpose is to ensure that information, quote, supplied by individuals or organizations to an agency, end quote, are used for the purposes for which it is provided. It is very specifically an external source limitation. Similarly, 8 U.S.C. 1454, which are about documents that are created by the Attorney General's office, it states that if a certificate or declaration has been lost, the applicant or any other person who shall have or may come into possession of it is required to surrender it to the Attorney General. Obviously, that language does not apply to documents created by these third parties. These are documents very specifically created by the Attorney General, and when someone else comes into possession of it, acquires it, they must surrender it.
Counsel, I'm going to ask you to slow down just a tiny bit.
Sure, Your Honor. DOJ points to statutes that have a broader scope, like FOIA, but those statutes use very different terms. FOIA applies to documents that are maintained by an agency, a broader scope because it uses a broader term. Even the statute that they talked about this morning, raised for the first time at oral argument, 44 U.S.C. 2107, talks about documents that are created or made available for use by, obtained by, or otherwise came into the possession of. Now, DOJ would argue that otherwise come into possession of incorporates every single term that came before it, but that's not how statutory interpretation works. The statute uses the term created because it does not mean the same thing as come into possession. And Congress knows how to write a broad statute. All of these examples show that Congress can apply, use a broad term, and generally does use broader terms when they're talking about these types of statutes. But in this case, they used a very narrow term, which was come into possession. And that is significant, as now held by 15 courts. That term does not apply to state voter registration lists. Interpreting come into possession as acquired is also the only way to make sense of the 22-month retention period in the CRA. You can't apply a retention period to a constantly evolving database that is required by HAVA and the NVRA to be constantly updated. And literally the state updates the state voter registration list thousands of times before a federal election. If you were to apply this retention period to this to each of those documents, the states would have to be preserving every iteration of those state voter registration lists every time a change is made. No court, no state, no election office has ever interpreted the requirements of the CRA as requiring that type of retention. And DOJ points to the criminal provisions to suggest, well, you don't have to literally retain those documents, but because they will only criminally prosecute when there's been willful destruction or willful alteration. But that's not what retention means. Again, they want to read retention completely out of the statute. We all know what it means to retain a document, and it does not mean to overwrite that document hundreds of thousands of times. No court has applied this because it really makes no sense to apply the CRA to a document that is required or a database that is required to be constantly updated under federal law. And in fact, that was a key reason in the Pilf v. Nago case that the Ninth Circuit concluded that the VRL cannot be a record that is required to be retained and produced under the NVRA's 2-year retention period. Now, while that language in the NVRA is different than the language here, it still just makes no sense as a logical matter to have a statute that would require the state to retain hundreds of thousands of iterations of the database over a period of time. That cannot possibly be what Congress meant, and that is just a problem that DOJ likes to ignore by focusing only on the criminal provisions, as opposed to the fact that retain does not mean rewrite over and over and over again. They would like to read out of the statute the term comes into possession. They would like to read out of the statute the term retain and preserve. They would like to read out of the statute the 22-month finite retention period. The only way to interpret the CRA consistent with the NVRA and HAVA, and that gives meaning to the use of the terms come into possession, as well as the retention periods, is to apply the CRA retention requirement to records that are acquired by election officers, not records that they create. This is alone grounds to dismiss DOJ's complaint, but even if the CRA applied here, DOJ has not met its requirements. It did not provide any basis whatsoever for its demand, and it has not provided a legitimate purpose for its demand. The basis cannot be a bare citation to the CRA itself. If Congress had simply intended for DOJ to cite the legal authority, it certainly knows how to say that. Requiring a statement of basis or purpose thereof is a very odd way to say simply cite your legal authority. Basis means factual support or foundation as held by at least 15 courts, which is entirely consistent with DOJ prior practice, as evidenced in the amici brief filed by former DOJ officials. DOJ's failure to identify any sort of factual support here is, again, dispositive. But DOJ also does not have a valid purpose. More than a dozen courts have determined that the purpose for a CRA demand must be related to the purpose of the CRA, which is to enforce individual voter rights. That doesn't necessarily mean that there must be a racial component in the demand, but it must be to enforce individual voter rights. It cannot be for the purpose of enforcing HAVA or NVRA list maintenance requirements.
Is the state already required by HAVA or the NVRA to provide documents that are generally related to the programs?
Yes, Your Honor, there is a 2-year records preservation requirement in the NVRA, but as held in Nago, that does not apply to state voter registration lists. And indeed, the Nago court said very specifically that compliance, determining compliance with NVRA's programmatic requirements really doesn't require an SVRL. And DOJ has never explained how that or why an SVRL, a static SVRL, is necessary to determine the state's programmatic requirements under the NVRA. And DOJ's stated purpose fails even on its own terms. DOJ claims that obtaining the SVRA is the only way that it can determine a state's compliance with the NVRA and HAVA. But again, that makes no sense given that the NVRA did not Neither the NVRA nor HAVA allows DOJ to have these documents. It really makes no sense that they're required to have these documents in order to ensure compliance when Congress never gave them the right to seek those documents on a pre-litigation basis. And that's consistent with Congress's intent to keep discretionary authority within the states. They have programmatic requirements, but the discretion and how to implement those requirements remain with the state. There is simply no authority for DOJ's claim that they should be able to superintend on a line-by-line, individual basis who is allowed to register and vote in state and federal elections. That is not DOJ's authority. It usurps states' constitutional authority. It violates the NVRA and HAVA, and it is inconsistent with the CRA. DOJ's efforts to obtain the sensitive information of hundreds of millions of voters cannot be separated from the all-out assault by this administration on elections generally. Its demand is unlawful, it is wrong, and it is dangerous. We ask this court to grant defendant's motion to dismiss.
All right, thank you, counsel. Counsel for interveners?
Good morning, Your Honor. Tyler Bishop for Intervenor Defendants Common Power and the Alliance for Retired Americans, and I'll refer to them as the Alliance Intervenors. I don't plan to use a lot of time here, and I won't rehash the full menu of deficiencies requiring dismissal. I want to broadly address two things from the perspective of Washington voters. First, the Privacy Act, as my colleague mentioned, which is the elephant in the room that DOJ has tried to but ultimately cannot run away from in these cases. Second, if I have a minute or two, DOJ is a historical spin on the Civil Rights Act, which matters because the real history here only further exposes the incompatibility of DOJ's stated demand with its sole claim for relief. Happy to take the court's questions, of course, or address other issues if you prefer. Turning to privacy, I want to zoom out before I zoom in. DOJ is asking this court to compel disclosure of a state database that links our social security data, driver's license numbers, birth dates, and other sensitive information to our addresses, party registrations, voting histories, and more. Public versions weren't enough. DOJ's complaint states at paragraph 22 that it needed that information specifically. DOJ seeks to frame this unprecedented demand as routine business of the federal government. Respectfully, Your Honor, it is nothing of the sort. It is difficult to imagine a cleaner-cut example of a stockpile of information about private individuals that is capable of exploitation at the federal level. Yet that, as the DC Circuit first put it, is exactly what Congress was focused on preventing when it passed the Privacy Act, and it gave the act teeth. So when we zoom back into the text of the Privacy Act as it applies to the complaint, it is not surprising to find that it pleads a demand that is facially defective, procedurally and substantively. On procedure, DOJ entirely failed to notice this vast new collection of personal records by publishing a System of Records notice, known as a SORN, before proceeding. The Privacy Act specifically requires a SORN whenever the federal government seeks to collect personal records of its people, describing, among other things, the category of individuals, the types of information that will be stored, and how the records will be used. DOJ's complaint recognizes this statutory prerequisite at paragraph 24, but alleges its data grab in Washington can be swept under several existing SORNs, but not one of them comes close to satisfying DOJ's obligations. The SORNs identified by DOJ speak in general terms about subjects and witnesses in specific investigations who have their information collected or used in connection with those investigations and cases. They simply do not cover the who, what, and why of DOJ's attempt to amass Washington's entire voter roll here. The text and history of the Privacy Act confirm that Congress imposed the SORN requirement as a mandatory checkpoint to ensure that when the federal government seeks to collect our personal information, its process is careful, grounded in legal authority, reasoned, and targeted to prevent potential abuses and misuses. DOJ's mad dash across the country to amass sensitive voter information runs roughshod over that core safeguard. DOJ's only counter on the merits of this question is to say that the SORN requirement is not a mandatory prerequisite. DOJ has recently advanced that argument in other voter roll cases and in other contexts involving this administration's use of data, but it has been repeatedly rejected as flatly inconsistent with the text and structure of the act. Among those courts is the District Court in Weber, which dismissed DOJ's complaint in California on this ground without hesitation and with prejudice. Just as it was there, DOJ's demand is legally defective when it issued. Even setting aside these procedural defects, DOJ's demand plainly violates the substantive use requirements of the Privacy Act as well. Most relevant, the Act prohibits DOJ from sharing records with other federal agencies unless the other agency's use for the data is compatible with the authorized purpose for the records under federal law. Despite its previous attempts to hide the ball, DOJ has now conceded that its master plan all along has been to run sensitive voter data through Homeland Security's SAVE database in an attempt to conduct what can only be described as a nationwide voter eligibility audit. But as several courts have recognized, and as has been discussed this morning, voter eligibility is fundamentally a state function, and there's no statute that authorizes DOJ to hold or use unredacted information in state voter rolls at all. Against that backdrop, there's no plausible authority for DOJ to further disclose that information to Homeland Security. In fact, a federal court in DC recently addressed whether disclosures of sensitive voter data for use in the SAVE program for purposes of voter eligibility could be considered compatible with any authorized purpose, and that court concluded in a final judgment that the answer is a resounding no. The Weber court, in essence, recognized that the same is true with respect to DOJ's crusade to do this for every state by directly obtaining those lists, even before the DC court reached that conclusion. And again, that court dismissed DOJ's complaint without hesitation and with prejudice. Finally, DOJ's threshold argument that the privacy defenses should not be resolved on a 12b6 motion is simply wrong. A failure to comply with Congress's mandates in a federal statute renders a demand for information legally defective, unenforceable, and subject to dismissal under the Supreme Court's decisions in Gelbard v. United States, Jones v. Block, and Ninth Circuit precedent. We've also briefed why the plain text of the APA and the Privacy Act support this result, Your Honor. DOJ, on the other hand, has not identified any concrete reason that this court should not dismiss on the plain-as-day privacy law violation standing in the way of this court granting it relief. Rather, DOJ claims that its demand is in full compliance, and this morning DOJ stood by its request for immediate relief. I'm happy to discuss any of these issues in more detail, but the bottom line here is that there is no plausible procedural or substantive legality to DOJ's demand under federal privacy law, and those are independent and sufficient grounds to dismiss the complaint with prejudice. Now, before I fully move on from privacy, I just want to briefly note that DOJ also can't overcome state privacy law either. DOJ has admitted that those laws prevent disclosure of the specific information that DOJ has demanded on voter rolls at page 31 of its brief, and DOJ has also admitted that it bears the burden of establishing preemption in this context by showing a conflict with that state law. But DOJ's theory about how federal law somehow conflicts with Washington's voter roll privacy laws simply does not add up. Even assuming in the abstract that Title III could reach a voter list, the Act says nothing about the particular sensitive information that DOJ itself demanded from the voter rolls here. Recognizing this, DOJ again invoked the NVRA and HAVA, claiming it needs that specific information to conduct oversight of list maintenance. But again, neither of those statutes suggest that DOJ is entitled to that information.
Counsel, most courts that have addressed this have not reached the Privacy Act issue, presumably because they have found that Title III does not apply. Do you have any thoughts on whether reaching the Privacy Act is necessary or why most courts are not reaching that issue?
I can't speak for the courts, but I would look to the way that the Weber court framed the Privacy Act issue. Essentially, what the Weber court concluded was that DOJ's demand is legally defective, not just because it failed to comply with Title III itself, but also because it failed to comply with federal privacy law. So in that sense, it's entirely deficient as it issued, whether or not DOJ is right about every single one of its other arguments. So for that reason, we would ask the court to reach both issues essentially, because as Judge Carter in California explained, the privacy issues are very important, in fact, foundational to our democracy, and the court should reject DOJ's efforts to run roughshod over those protections. Now, just very briefly, before I wrap up, I do just want to add a note to on the DOJ's counter-argument about the history of the Civil Rights Act. And again, I'll keep this brief as we fully endorse what my colleague from the state has said about the text of Title III and the reasons it requires dismissal. The DOJ is right at the outset that the act was meant to prevent the unlawful disenfranchisement of Black Americans in southern states like Alabama and Texas. But from there, the DOJ's argument departs from reality. According to the DOJ's account, in the 1960s, it could not have investigated states effectively without access to sensitive voter list information. That is an egregious misrepresentation of the relevant historical record. As some courts have already recognized, the Sixth Circuit and district courts in California and Oregon among them. The historical record, in fact, shows that Congress was focused on preserving papers and records officials received from aspiring voters, not state-generated lists. In an earlier act, Congress had already given DOJ responsibility to investigate potential voting rights violations, but officials in some states had become notorious for evading accountability by destroying or distorting applications submitted by qualified Black voters, as the Civil Rights Commission found in its 1959 report. Only by preserving those records could the DOJ then show that qualified citizens were still being unlawfully shut out of the democratic process under the shameful rule of Jim Crow. Congress's use of comes into naturally limits the statute's reach to target that harm and avoids an overbroad interpretation that conflicts with other aspects of the law, as my colleague discussed this morning. And this account has also been confirmed by leading historians and amici briefs opposing DOJ's demands, which we've cited in the briefing. To sum up here, every defect is apparent from the face of DOJ's own complaint, the relevant statutes, and the materials that DOJ has put before this court. We ask that the court grant our motion to dismiss with prejudice and deny DOJ's motion to compel on any and all of these grounds. Thank you, Your Honor.
All right, thank you, counsel.
Good morning, Your Honor. Renata O'Donnell on behalf of Intervenor Defendants Common Cause and Washington Conservation. Your Honor, I represent Common Cause's 32,000 Washington members and Washington Conservation's 3,500 members who have intervened in this case because it is their personal, sensitive data that's in those unredacted voter rolls. Because the Department of Justice has failed to comply with the conditions that Congress expressly set out in Title III of the Civil Rights Act, we ask that Your Honor join the, as of now, 20 district courts and 1 court of appeals to deny the pending motion to compel, grant the motions to dismiss, and hold that the Department of Justice cannot access that sensitive voter data. Your Honor, today I'm going to talk to you about the pretextual nature of the Department of Justice's demand. But before I do, I want to address judicial review in this case. As Your Honor explained, whether or not the federal rules apply in this case is not something that necessarily dictates whether or not the Department of Justice can get access to those unredacted voter rolls. But I want to draw your honor's attention to what the Department of Justice is asking for here, because it's really extraordinary. After filing a civil complaint, the Department of Justice comes before this court and says, because we issued a written demand, and because the state of Washington has said no to handing over the unredacted voter rolls, on that basis alone, we are entitled to the unredacted voter rolls through a court order at this point in the litigation. And that Your Honor can't question the basis and the purpose of that demand. Functionally, Your Honor, that would sidestep this court's review. And judicial review has to apply in this case. It cannot just be that the Department of Justice gets the game ball at this stage in the litigation by saying that they have issued a written demand. Your Honor, as 17 courts have held, it's not just that judicial review applies in this case, but that the federal rules apply. Now, Your Honor, as to the pretextual nature of the Department of Justice's request, the purpose of the Department of Justice's request is pretextual, and it is insufficient to get access to the requested unredacted voter rolls under Title III of the Civil Rights Act. As my colleague for the Secretary of State explained, the proper purpose is to enforce voting rights, to enfranchise people under the Civil Rights Act. The Department of Justice's demand is to assess Washington's compliance with the statewide voter registration list maintenance provisions of the National Voter Registration Act. That's their purpose, according to their papers, ECF 76 at 12. But that's just not plausible. The unredacted voter list wouldn't show them anything about any potential violations of the National Voter Registration Act. The unredacted voter list instead would only show what the redacted voter list would show. Under the NVRA, Washington has to implement a general program that removes people when they move addresses or when they die from the voting list. The redacted and unredacted voter rolls, which Washington has offered up those redacted voter rolls, would show whether or not such a general program exists. Your Honor, we also see the implausible nature of the Department of Justice's stated purpose because we see that this is not an investigation that is tailored to Washington. To the contrary, as evidenced by the papers that we attached to our motion to dismiss, we see that the Department of Justice issued nearly identical letters to be sent en masse to 48 states, requesting access to unredacted, sensitive voter data. And when they didn't get access to those unredacted voter rolls, the Department of Justice didn't ask the types of questions you would expect for issues with voter list maintenance, for ensuring that those voter lists are up to date, such as when do you send postcards to people to ensure their addresses are up to date? How do you assign unique HAVA identifiers? No, instead of asking those basic questions, the Department of Justice filed lawsuit in state after state after state after state, amounting to over 30 in total. That demonstrates that the purpose that the Department of Justice has in asking for Washington's unredacted voter list is not an investigation into whether or not Washington is complying with the National Voter Registration Act. That looks like an effort to amass as much voter data as possible. And that is not a permissible purpose to ask for the unredacted voter rolls under Title III of the Civil Rights Act. To close, Your Honor, millions of Washington voters, including Washington Common Cause's members and Washington Conservation's members, registered to vote with the expectation that their data would be used only for that purpose and would then be kept confidential. There is a real cost to a vibrant democracy in disclosing this data to the Department of Justice when it has failed to comply with the requirements that Congress set out for it in Title III of the Civil Rights Act. For these reasons, and the reasons stated by our colleagues, we respectfully request that this court grant the motions to dismiss and deny the motion to compel. Thank you, Your Honor.
Thank you, Ms. O'Donnell. All right, Mr. Chang, I'll give you about 15 minutes to follow up.
Thank you, Your Honor. Good morning, Your Honor. I'll make some comments as in the order that I've heard them. Secretary Hobbs described that Title III was not about allowing individuals to register to vote, but if Title III was about anything, it was about inspecting the actions of election officials in any act requisite to voting, which has to include, especially today, the ability to register, and especially in registration practices. Even the individual right to vote includes a protection against the debasement and dilution of a right, to wit, whether any person can vote even if they're not qualified to do so. Your Honor asked a question about whether some application could hypothetically be kept for 100 years. We said yes, that's because we agree with the Lynn Court, especially in footnote 2. And I quote, "Thus, for example, in Alabama, where registration is permanent and re-registration is not required, this would extend as far back as the earliest application for registration of any person eligible to vote in the most recent federal election." I think that's appropriate. There was also a comment about the JFK Act, where the argument goes that created or made by is distinct from coming into possession because they use both. If true, then that means that coming to possession is distinct as well from obtain, and it follows what exactly does coming to possession mean if it does not include either internal or external records. A big argument that is underlying the defendants is that record cannot be dynamic. I think the fair reading is that a record could be dynamic. Updating is not altering because the record still exists. And as we understand, as the federal government understands Section 302, the altering has to be for the purpose of misleading what the record did. I mean, in basic terms, a record is supposed to memorialize what happened. So long as a record, static or dynamic, is accurately memorializing what happens, it doesn't fall under 302. And that's before we can get to the willfulness part. The Nago case they mentioned, I would hesitate to read the language semantically in the way that they imply, which is hypothetically, if the phrase related to list does not include list, I would hesitate to read that sort of relationship into Title III, because if an act of registration, the argument goes, is a list, then any record relating to an act of registration cannot include a list. That is an argument without merit because it is an argument without limit. Applying it to an application would mean that Title III does not even cover application forms at all. One of the defendants mentioned amici prior practice. I want to note that our prior practice is inconsistent with external source limitation, as many of the dissent decrees and the other judgments reveal the documents that were demanded and turned over are documents that are not submitted by voters, but are created by election officials. I want to be clear that the United States is not actually doing the late list maintenance on the list itself, because we wouldn't be getting the actual list. We would only be getting a copy. At most, what we are seeking is to establish whether they have done a reasonable list maintenance. But the federal government has no power to force a state election officer to add or remove any name. Now, if the United States, for example, tells a state election officer, you perhaps have individuals that are not qualified to vote, and they don't do anything about it, that might give rise to cause of action where they have done reasonable list maintenance.
How does the sensitive information that the United States is seeking support the stated purpose of evaluating a reasonable maintenance program. Why do you need the last 4 digits of a social security number or a driver's license number to do that work?
Thank you, Your Honor. I was about to address that. That's because HAVA requires it. I think the way we read the
I'm sorry,
federal government-
HAVA requires,
HAVA requires the presence of the last 4 digits of social security number or a driver's license number or state-assigned HAVA identifier for this SVRL system that's required under HAVA.
right, so the state is required to have that information, but how does the federal government obtaining that information advance its stated purpose of evaluating list maintenance programs?
Well, Your Honor, our letter is more general than that. It's both to enforce NVRA and HAVA. It, in our view, would be a HAVA violation if we were to give in the full SVRL, and it turns out they were not assigning HAVA numbers where that voter applicant did not provide the last 4 digits of a social security number or a driver's license number. HAVA requires it. I think the way to synthesize HAVA and even NVRA with Title III is Title III of its own independent force does not require the generation of any records. HAVA clearly does require the generation of a record. So long as a record is generated, it is covered under Title III. And therefore, a public version of an SVRL is not enough because the U.S. is investigating whether the state has done its required duties under Section 305A5 to provide such information and to assign such information, if necessary, to statewide voter registration list. I think one of the defendants mentioned the DC judgment against the modern SAVE system. If anything, that helps us because we're not using it. We have at this time, no intention of using it. We're simply investigating whether they are complying with the list maintenance requirements of the NVRA and whether they are furnishing the required information under HAVA. I also want to note that the federal government is not limited to, say, a 1 demand per election cycle. The fact that we did not request everything that we have the right to under Title III does not foreclose that in the future we get the SVRL, we like more information, we can make further demands. Title III does not limit the Attorney General to only 1 demand for a limited time. I think the state privacy law argument is really just coextensive with Title III. We believe that if Title III covers the requested record, then it is preempted. And if it doesn't require Title III coverage over SVL, then state privacy law is of no concern. However, it is odd that, as a factual matter, Washington can share the same info with other states and even a nonprofit through ERIC, but is now denying it to the federal government. Apparently, state privacy law allows that disclosure information to certain entities, but not the federal government. We agree that judicial review is appropriate. The disagreement is to what extent. And as the Lynn Court said, the judicial review contemplated under Section 305 is limited. That is part and parcel why the federal rules don't really apply, if at all. And the requirement to demand the SVRL is not subject to a best fit paradigm. Again, Title III already covers all records and papers. They're required to retain it. And the fact that we only demanded a subset doesn't cut against whether Title III, as a matter of statutory interpretation, covers it again in the first place. I think the district courts, unfortunately, have interpreted Title III basically beyond recognition to what people back then would envision it doing. It enacted a general inspection system by the Attorney General, again, not requiring the creation of any record relating to act requisite to voting, but any record that a state creates in its election duties, whether it's required by state law or now by federal law, is subject to preservation and retention and is subject to a demand for inspection, reproduction, and copying by the Inspector General, the Attorney General. I also want to note that in the briefing, they mentioned Greater Birmingham Ministries to say that electronic reproduction is not permitted. If anything, that case actually helps us because the NVRA uses the specific term photocopying. That term does not appear in Title III. They use the word copying, and even the panel in Greater Birmingham acknowledged that copying can include electronic reproduction. We also don't think that any demand is subject to the problem of a static record. The way we view Title III is if we requested, say, the SVRL 2 months ago, but we were granted an inspection today, again, since Title III covers all records and papers, we would be able to look at the record as exists on the day of inspection. So we don't think that a request is tied to a snapshot or a specific point in time. What is specific to a point of time is the 22 months in reference to a general election, but not to the records themselves. And for that, we ask that this court grant the United States motion to compel and deny defendants and interveners motions to dismiss. Thank you.
All right, thank you, counsel. All right, does the state wish to make any follow-up?
Not unless Your Honor has further questions.
What about the interveners?
No, Your Honor.
All right, thank you. The court will take the motions under advisement and issue a written order as soon as practicable. I want to thank all the parties for their thorough argument and briefing this morning. Just by accident of the calendar, we are here on Election Day, so these issues are certainly timely, and I appreciate the time and attention you've all provided to it. I will render a decision as soon as possible. We'll be in recess. Thank you.